Good morning, distinguished ladies and gentlemen. All protocol observed, please pardon me. Dennis, I think we will have to change this bio. We will have to change this bio at some point because. So this topic is quite close to my heart. Dennis says I should start with a story. So I am a mother of a child with severe disabilities. This is how I got into the circuit in the first. And I think for many people who are in the disability space, it is very personal to us. You typically have to have experienced it to see some of the challenges. But because I'm a mother of a child with disabilities, and I'm a single parent, which is also quite cliche, sadly, it was part of the statistics. But that brings us the question of maintenance, because particularly when we are dealing with children with disabilities, the cost implications are staggering. Depending on the disabilities, in my case, my son is non-verbal, non-mobile, non-sighted. So every therapy you can think of is needed. And 24-hour care. That is it takes a budget all by itself, right? So this topic is particularly important for us because it's not spoken of very often. So thank you, Dennis, for allowing me to bring this into our conference today. So can we go back, please? I think they're trying to hurry me up, so let me just... So we're dealing with maintenance, the legal framework, as always, the Constitution of Ghana. You'll find some in the Matrimonial Causes Act, you'll find some in the Wills Act, PNDC Law 101, which is the Intestate Succession Act, the Children's Act, and of course, customary law has rules. We won't dwell too much on the customary law rules today, but yes, so from the Constitution, we have the duty of maintenance is imposed from the Constitution. So you'll see that and it's interesting that it's a non-discriminatory sounding clause, right? Because every child has the right, which includes children with disabilities. The challenge with creating general rights is that very often special children they fall through the cracks, as we will see. So every child is entitled to the same measure of special care, assistance, and maintenance as necessary for its development from its natural parents, unless they have surrendered through adoption and other means. And so the concept of maintenance is seen as a natural right and obligation. It comes with the territory of being a parent, that you are required then to maintain the children that you have created. Wish I had a point to move it myself so I can, okay. So I split this conversation in two for us to see how the law deals with them. So I actually have a paper, and once again to thank Dennis for allowing academics to, otherwise people will not know what we write about. And so I have a paper on this, and I split it into two because I look at how the law deals with the question of maintenance when the parent is alive, and then when the parent has passed on. So when they are alive, we are dealing with the Children's Act, you're dealing with Matrimonial Causes Act, and then customary law. The duty of maintenance is so important that at custom, while it is on the father, the first point is that it's on the father, and two, it is so important it's passed on to the successor after death. So it doesn't terminate just because your father has died. His successor is mandated to take up the job of maintaining the children. And I believe it is even in Menu and Kuma where the court said, if the mother has, in the meantime, been taking care of the children, paying bills, she's entitled to even claim it from the successor because it is his job to take over after the father has passed away. So that's a very important thing for us to understand, that maintenance is a natural thing, but it is also a legal question. It is created by the Constitution, it is recognized under customary law, and it is seen in our statutory framework. So to give us a bit of a sense of why this question is important, I wanted us to look at the sociocultural context within which maintenance finds itself. Now, the first thing that I wanted to think about is the way in which our roles are very gendered. And so when it comes to care for children, generally speaking, we are structured such that women typically have the care of children, and the Constitution very sadly ossifies this position in Article 27.2, it's one of the things that I teach when I teach gender in the law. What is the value of the things in the commas? Because it says special facilities should be provided for women, for children with school-going age, so that then the commas, so that women, comma, who have the traditional care of children, comma, can achieve their full potential. And I always ask my students, analyze this clause. What is the value of the information between the two commas? Because if we had dropped it, if we had said special facilities should be provided for women, for children of school-going age, to allow women to achieve their full potential, it would be implied, but it's not as clearly. This one has kept us in the space until we amend this. And for those of us who are in constitutional law and theory, understand the value of the values that the Constitution espouses. So, in the context of our conversation, typically the child with disability will be in the care of their mother. And that means in the situation where you have a divorce, the custodial parent is very likely going to be the mother. So this also takes on a gendered hue as well. Now, that then brings us to the concept, the idea of, so what does that family look like? Typically, they are lower in income. The families tend to be single-parent families, and as we said, that single parent will often be the mother, which will mean that the one who has the duty to pay maintenance will be the father. So very typically, this is what you will see, that one, the family will be struggling more financially, and two, the one who will be required to pay will be the father. The interesting thing I found is also that a significant caseload of the institutions in charge of child welfare, so welfare, family tribunals, is on maintenance. And you have a significant number of men avoiding that obligation of maintenance. So you have to go to court to get them to pay. Even that one, I am informed that it's on paper, but as to whether in practice the men will still pay is a different matter. So there is a big problem with maintenance, generally speaking. And I dare say, if you think about maintenance of children with disabilities, it's an even more problematic space because of the stigma attached with disability. So a lot of people would like to distance themselves even from their own children with disabilities, which would mean that if we are going with the setup we have just described, where it will be a single parent family and it will be the mother who will likely be that single parent, it would mean that the father appears to have some freedom to decide if he will maintain or not, unless you have a court backing your rights there. So next one, please. So you have, I thought this was hilarious when I saw it yesterday, so I put it in there, but you have this unfortunate cycle where men and women earn differently because of we have income differences, you have wealth differences. So women typically would have less income. They would likely be the single parent. That would mean they will be the residential parent with a significant payment issues, and that will lead them to more costs, which would also mean more impact on their already impacted income. The data connecting poverty to disability. So the poorer you are, the more likely you are to have disability, because of course some of them are healthcare issues that don't get taken care of. So the poorer you are, the more likely you are to have a disability. And interestingly, if you are disabled, you are also more likely to be poorer. So it's an endless cycle. And that is why this topic is important, because maintenance allows us, at least in part, to sort of close those gaps and to cut that cycle somewhat. So this cycle I'm describing, so we have the economic disparities, you have the poverty, you have disability, which then leads to the stigma, then leads to discrimination, and then discrimination also then causes more poverty. So you have this endless, a rather disturbing cycle in which we have to fix, and maintenance is one of the ways in which we fix, as beautiful as this picture is. I'm hoping that we can go back to our slide so that we can follow the conversation. I do appreciate the compliment, though. So, given this context that we have set out, the law, the sociocultural spaces, the realities that we face, what is the problem with maintenance? We haven't actually dealt with the problem of maintenance. Oh, wonderful. Okay. What happened to my writing? Okay, never mind. As I tell my students, this is why you should do your own work, so that even if you have a problem like this, you know exactly what is inside here. So the first problem, and so we've broken the problem into different pieces so that we can sort of see how we can, because they have different solutions, right? The first problem that I identified was even in the factors for making the orders. If we have maintenance orders, a court is required to consider certain factors, and the Act 560, that's the Children's Act 1998, gives those factors, which are the impairment of the earning capacity of the payer. Right, so they have to look at, maybe he's had an accident, maybe there's some other challenge. What has impaired his capacity to pay? What are the responsibilities for other children? And in our context, there will be other children. Very likely there will be other women. So you can have a situation where you have one woman who has a child with disabilities, and it's not unusual to find that because of the stigma, again, the stigma related to disability, the mother of that child, there are situations where, and I have seen them actually happen, where the husband is encouraged by his family to marry someone else because this woman, to put it in tree, to wit, her womb is not good because she has had a child with disabilities. So there are very likely going to be other children. So the court has to look at what are his responsibilities for other children. And then the income and wealth of both parents, the cost of living in the area of the child's residence, the rights of the child under the Act, and other. Nowhere in the provisions there do you find disability. But there are kids with disabilities, either born with disabilities or who develop disabilities over time. And as we've mentioned, the cost of caring for a child with disability, some studies have said it's as high as 3 times as much. And I can tell you, as a parent myself, I think it's 5 times as much, because if I compare what I spend on my son to what I spend on my daughter, I mean, they're not comparable, actually. So it ought to be a factor that we should consider, because when you are putting the needs of children together, if you don't have disability in there, the challenge will be that you create utilitarian decision making. So the judge has to decide, he has 6 children, one of whom is disabled. The 5 of them can go to school, and they will start comparing and looking at which one is better to invest, and then you have a whole storyline about how, but if they invest in these ones, they can grow up and help take care of the child with disabilities as if it is automatic. So invariably, I think that the child with disability will lose out on maintenance, especially when you must compare the other needs of other children. So if you are going to find a child with disability, you have to put him in the other, which means that you are leaving it to the discretion of the judge to decide, 1, if they will consider it because they're not mandated to, and 2, how much consideration to give to that, because it's fit into other, and other is so big that there are different concerns also that can fit in there. So again, you have competing interests, and the child with disability is unlikely to be prioritized over other children. The same problem you find in extension, or when they're extending the order. Beyond 18, you have to extend the order if the court decides to do so. There are only 2 grounds I could find in the law for extending the order. So if the child is beyond the age of 18, the maintenance order should have lapsed, but if they are undergoing educational training, then the order can be extended under Act 560. Under Act 367, the matrimonial courses, the order is extended again for training, education, or if the child is permanently incapacitated. So if the child is not permanently incapacitated, the court does not need to order the extension. So if you're going to be, in other words, if you're going to be disabled all the way. Don't stop halfway, because the law won't provide anything for you. Why should I be permanently incapacitated before I can get support from the parent who birthed me, right? Why should it end at a certain age? So this leads us into the next problem, which is the age limit. Maintenance orders terminate at 18 under Act 560, terminate at 21 under the Matrimonial Causes Act, unless they are extended for those reasons we have discussed. The Constitution, which gives us all these rights we discussed earlier on about the duty to maintain, also says 18. For the purpose of that provision, child means person who ends at 18. The Wills Act, which allows a child or a wife or a husband or a father or mother who has been left out of the deceased will to apply within a particular time, citing, proven hardship that your parent has left you out of the will and has caused you hardship, and so the court should provide for you. That provision also 18. So if you are above 18 and your parent leaves you out of their will, in this case I suspect to be a father who will leave you out of the will, and I am fortified this submission by Mensa-Bonsu and Akyiaa, which is the only case that we have on this side, which also is a father. It means that once you have crossed 18, there's nothing the court can do for you. It doesn't matter how sad, it doesn't matter how much hardship it causes to your mother, it doesn't matter what the challenges are, 18 means 18. So it's one, from what I could see, it appears that there's a bias in favor of married women. Because if you are married and you are going through a divorce or something, then Matrimonial Causes Act will allow you 21. So you better pray that your parents got married, so at least we can extend to 21. But then that brings the question of who carries the weight then? Because everybody here knows that, this one is not generalization, everybody in this, we will not admit of any challenge to this statement, that nobody at 18 in this country can survive easily. It is impossible. But the law presumes that at 18, you have a certain ability to self-sustain. It might be hard, but you can self-sustain. But if you are a child with disabilities, the factors, everything changes. The indices change for you. Accessing the labor market is not the same, even if you don't have a severe disability. So if you have a severe disability and you can't go into the market space at all, then ending maintenance at 18 is one telling the father, it's okay to do small until 18, then be free. But that means that someone else must carry that weight. Someone else must pick up the slack, or else the child must die. Now, if you are left with the decision of pick up the slack or the child must die, really the answer is it depends. It's not automatically, oh no, I'll save the child. But if you can't save the child, automatically you are saying the child should die. So it is no surprise that children with certain disabilities don't survive very long. Because you are putting survival, their survival and their mother's survival and other children's survival on the same level. Somebody has to lose out. Invariably, if the law doesn't protect children with disabilities, and in this case, dependents who have crossed that bridge, you are leaving them to a life of either begging or the mother having to carry the slack, which will mean that a father can go free, the mother cannot. I think you've gone one. Can you go back one bit, please? Okay, yes, all right. So this is our problem with the age limits, that they don't correspond with the needs of the children, the dependents with disability, because at this point you have attained the age of majority. The law says hands off to the parents, but it only says hands off to the paying parent, not hands off to the residential parent, who still will have bills that they have to pay. Because again, and if you think about it, the criminal law requires you, if you are the one to provide necessaries, to not withhold necessaries. So if the child dies under your care because you withheld, you will go to jail as the mother of the child who withheld and caused harm through her negligence or through withholding necessaries of life or whatnot. So we have a punishment to ensure that parents and guardians maintain the children that they have, but we also then allow one parent to get away from that obligation and punish the other one if they cannot sustain it. In which world does this work out as fair? So again, the age limit is a big problem for us. The next one, please. The third problem is that when the person who is paying, the one who has the order to pay, dies, the order terminates immediately. So to give us why this is a problem. Think about if you were the residential parent, right? And there's a maintenance order, say that it's supposed to terminate in 5 years. You have a legitimate expectation that for 5 years, you have some support. You're not the only one carrying that burden. Is that not reasonable to say that for 5 years, I should be able to depend on this as backup, as support? Because it's unlikely to be a whole lot of money unless you are dealing with a very wealthy spouse. But whatever the situation is, the person has a legitimate expectation of X number of years. This person should be able to contribute his share of the parenting cost. You die 2023, 2 years, there's excess 2 years. Who carries the weight those 2 extra years? Because the law says it terminates when the person has died. So there's no further payment coming. But if you had planned with that money for 2 years, now you have to figure out how to survive on your own. And as I put in the final slide, interestingly, dead men pay taxes. Abi, before the dead man pay, your estate will be charged. If you have any tax, you will have to pay tax. If you are inheriting, you pay tax. But if you are paying maintenance, you go free. At which, if dead men can pay taxes, dead men should also be able to pay maintenance, at least for some time, so that you don't suddenly tilt you don't upset someone's world and they have multiple bills coming back to back. Next slide, please. Next slide, please. Okay. Now, all this is while they are alive. When they are dead, you have either you're going under the Intestate Succession Act if there was no will, or you're going under Act 360 if there was. Again, the same problem of the age limit, regardless of the hardship caused. And this you find in the case of Bonsu and Queno. And one of the plaintiffs was a child over the age of 18, was severely disabled, permanent, pretty much incapacitated, needed care 24/7, but he was over 18. And the trial court tried to do some creative, thinking about, 18 is placed there because of the mental capacity you think you should have and whatnot, and this person clearly cannot survive on appeal, because interestingly, his family people appealed, the father's family people appealed. The court said, it's sad, we know. It's hard to watch someone like this, but 18 means 18. There's no ambiguity about it. You can't be creative and look behind the law for something when there's nothing ambiguous on the face of the law. 18 means 18. So that child has no support, that dependent has no support because they've caused the age. Now, so what we are saying here is that every time you exclude a dependent with disability from accessing the maintenance from the father, automatically the mother must pay 100%. And again, if you're thinking about the cost of disability, the implications of disability on even the woman's ability to have a job outside of the home, because many people can't afford it. I am extremely privileged to have a very large village of support backing me. Without that, I wouldn't be able to afford the life that I wouldn't be able to go to work. So there are so many others who don't have that capacity, who don't have the village of support that I do, that to cut maintenance at a particular age and say it ends here means that someone else automatically must do the work. That person will be the mother. If you think about our family systems, matrilineal, patrilineal, if we are matrilineal, it's even worse, because at custom, the child doesn't belong to their father. So really, there's not that great attachment in the first place, customarily. You have to use law to force it. Otherwise, it's very likely that the father's family does not have any interest in there because it's not their family member. It also means, because we've discussed the stigma already, it would mean that the social space does not support that mother either. So it is not easy to find financial support from society as well. If we come to PNDC Law 111, all children are treated as if they all cost the same. They are all alike. Even when we were bothered to think about an amendment, we talked about the school fees, the cost of maintaining a minor child through its educational training. That was our only concern. What about the cost of a child with disabilities? If there is one in there, that child will cost more than the other children. But if you treat them all alike, they all get the same entitlement, then they must compete with all their siblings for the same amount of money. And that means that there will be less the equality there will actually lead to inequality, because they will end up with less to survive on than their siblings. So we have a lot of, and then again, even the extension based on educational training, even if you're thinking about educational training, what does that mean? Very likely the law will think of a recognized educational institution, like in our tax laws. So will speech therapy be covered here? Will occupational therapy be covered here? Will physiotherapy, which many children with conditions like cerebral palsy need to survive, would it be considered here as part of education of that particular child with disabilities? That's unlikely. So we can't even fit them into such broad statements as educational training. You have to provide specifically for them. Next slide, please. I'm wrapping up. So we've mentioned all of these things that privileges men, that generally the framework privileges men, and disadvantages women and children. Cutting it at 18 or 21, this is when the child will maybe have even more difficulties. They are older then, they are heavier. You can't lift them and put them behind your back as you would as a baby. The mother is also older by that age, so may have their own medical bills. That's the time you are cutting maintenance. You are doubling costs. And so it will increase risk of poverty. It's, the state condoning discriminatory treatment, which is contrary to its own Article 17, the right to equality and the right to freedom from discrimination, all in there, is contrary to that value that we have expressed. And again, we mentioned the utilitarian decision-making. You are pitting children's needs. Invariably, education will trump other needs. And that contributes to that cycle of poverty that we discussed, leading to more stigma, more discrimination, requiring them, as we see many times in our societies, to live off charity and sympathy rather than they are human beings with human rights on their own. Next slide, please. So the final slide, the proposals for reform. I submit that we should rethink our age limits. It should not be so much about age, particularly for disabilities. It's about your ability to survive on your own. And that allows us to look at what disability you have. If your disability is dyslexia, compared to a disability that is permanent incapacitation or non-sighted, it allows the judge to be able to see what you need so that we can see at least how much longer we can extend. It is possible to say